Sam Ehrlich is an assistant professor of legal studies at the management department at Boise State, and he has been researching and focusing on the legal aspects of athlete labor and employment. He's put out several academic articles in connection with this. He has a lot of interest in getting more clarification on these antitrust laws for the NCAA based on their desire or their public stance of wanting to preserve amateurism in intercollegiate athletics. Recently, Sam, on his own behalf, put out what they call an amicus brief with the U.S. Supreme Court, which are very valuable and helpful in the way our Supreme Court rules on things. And he put a paper together about a three-tiered circuit split, why the Supreme Court needs to take some action on this Alston versus NCAA case. And he is joining us here on the Kingdom of Pod to talk about all of that. And I want to just say this, Sam, a Florida State guy, a lawyer, a former, you are probably still a current baseball guy, a first-year assistant professor there at Boise State. You've done a lot in your young life so far. How are you doing?
Well, I'm flattered to, be called young. I don't feel young all the time, but no, I'm great, and I appreciate you having me on, Jeff.
Yeah, I wanted to say that when I saw the word amicus, I'm not don't have a legal degree, and I'm not a lawyer, but I had to look up automated management information civil users system. I said, okay, that still means nothing to me, but you're trying to influence the U.S. Supreme Court's opinion on why the antitrust argument with the NCAA and athletes' education-based compensation needs more analysis. So tell us and remember, we're talking to Boise State football fans here, what your thoughts are about this case with the NCAA, because it's going to get a lot of attention here probably in the next year.
Absolutely. And, I think it's a major, incredibly important case for NCAA football, NCAA basketball, really all the NCAA sports. We're coming up on, we're now less than a week away from oral arguments in this case. So I think it's going to be something that's really going to be central in a lot of people's minds. And my role in this, is a very small part of this case. As you said, I wrote actually a couple of amicus curiae briefs. Amicus curiae, it's Latin for friend of the court. So essentially I'm a third party. I'm stepping in here and I'm kind of giving my opinion as a third party, saying, this is how I feel about this case. This is how I feel you should rule on this case. This is what I feel like you should be doing in this case and why this case is so important. And as you mentioned, I had written an academic article, actually as part of my dissertation at Florida State, talking about this three-tiered circuit split. And what that means for lay people is essentially that there's a lot of confusion among the lower courts, among the courts that kind of report to the Supreme Court, are influenced by the Supreme Court as to how to actually apply this complex field of antitrust law to NCAA amateurism activities. There's some courts that have said, well, if you're taking money out of college athletics, if you're doing that by creating this amateurism system, if you're taking money out, then it's non-commercial and the antitrust laws don't apply. That's one minority rule. There's another courts that has said, well, because of this, longstanding Supreme Court precedent, we're going to say that presumptively speaking, NCAA amateurism rules should be considered to be legal under the antitrust laws. And then you have this Alston case that's now been appealed to the Supreme Court, that the Supreme Court has now taken, that has said, we're not going to give that much deference. We're still going to require the NCAA to really justify why their amateurism rules, why these, restrictions on compensation are legal under the antitrust laws. And in this case, we actually found that they didn't do their jobs. They didn't justify why having restrictions on education-based compensation is something that is actually legal. So that's really what I stepped in to do here. That's, this circuit split is something the NCAA had pointed out in their own brief, arguing, asking the Supreme Court to take the case. I had originally stepped in as, in my own brief to say, yes, there is the circuit split. Yes, there is this confusion, but I see it in a different way, where I see that the case that's being appealed right now is actually the correct approach. There shouldn't be any real deference to the NCAA here without congressional action, without Congress actually saying that it's okay.
All right, Sam, we're going to circle this all the way back to name, image, and likeness, which Boise State Athletics has already taken movement on by hiring two different companies to assist the athletes at Boise State in the future with marketing themselves so that they can go out into the competitive market and market themselves as an influencer for brands, or some maybe giving gymnastics private lessons to people in the Boise area, or a quarterback doing a camp in the summer. All of these different things may or may not be happening for Boise State in the future, but they've hired a couple of different companies to help navigate this for the athletes. And I think we'll get into the name, image, and likeness piece, but one of the things about the antitrust exemption and the NCAA's argument, Sam, that I know you've studied, and I want a synopsis from you, is this whole idea of competitiveness, of if Alabama truly, which has the largest football budget in the country, is only going to offer as much to a student athlete in compensation, whether that be education, training, or whatever else, as Boise State can or will, that's a restraint of trade almost, and it's not necessarily the way things could or should be. But explain that for us a little bit more from your perspective, and bring that home.
Absolutely. And I'm really glad you used the phrase restraint of trade, because that's all of what the Sherman Act, the Sherman Antitrust Act is about. It's about prohibiting illegal, unreasonable restraints of trade that are deemed to be, inhibiting competition between different organizations, between different people, inhibiting, competition in economic markets. And kind of one of the best ways to think about this is, one kind of little piece of antitrust law is that it prohibits price fixing, where if two people are up for or if you're up for two different jobs, for example, and both of those jobs are competing over you. They both want you as a person, as a college athlete, as a radio host, as a professor. And because of that, they're going to compete for your services. They're going to offer maybe a higher salary, or they're going to offer better benefits. And that's exactly what antitrust law is designed to protect. That is exactly the economic competition that antitrust law is designed to protect. So the NCAA stepping in, according to the plaintiffs in this case, according to the Alston class in this case, by the NCAA and the member schools stepping in and saying, well, we're not going to allow this competition. We're going to set the price at an athletic scholarship, a certain amount of money in stipends, a certain amount of money for food, all these different things. That's exactly what they're fighting. They're saying without this competition, by restraining this competition, you are breaking antitrust law.
Yeah, and the NCAA does not want to see that broken, or they're going to get in the role of making athletes employees, insurance, and having to pay them, and basically becoming a professional sports league. And it would, I guess, change amateurism and intercollegiate athletics forever.
Absolutely, for sure.
Yeah. All right, Sam. Let's get back to, and I don't. I know you're a baseball guy, but I'm sure you're enough of a college football guy. If you went to Florida State and you get your law degree from there, is that right? Or you got your master or your doc? What'd you get there? PhD?
My PhD in sports management.
Okay. All right. So you've followed football enough by now, but there's an argument out there for the college football playoff that the group of 5 schools, of which Boise State's the most prominent, don't feel at times that they are being treated fairly to get equal access to the college football playoff and play one of those top 4 teams for the national championship. I know that's going to come circling back, but let's leave that conversation, because the name, image, and likeness conversation has Idaho implications. There's 11 states in the United States that don't have any pending state name, image, and likeness legislation. We've got all kinds of other states out there, dozens of them, frankly, with bills in the works, and Florida's ready to go into effect coming up like July 1. Iowa would like to do it tomorrow. So the NCAA is looking to Congress. They want a federal law that would preempt all the state laws. Idaho's doing nothing. Do you have a snap read on why maybe Idaho is one of those 11 just sitting there doing nothing while everybody else is?
I think, honestly, it's just not been a priority for them. I think they've been concerned with other matters. And usually with a lot of these states, and this isn't always true, but with a lot of these states, there are 2 driving forces as to why NIL legislation gets proposed. One is that you have one particular lawmaker that takes a special interest in it, maybe a college sports fan, or maybe someone who has been approached by one of the universities, asking them to create this legislation, to draft this legislation, propose this legislation. And I think a lot of times you look at these different states and you see that one individual lawmaker who's really leading the charge in that action. The other driving force here is actually competitive balance. Is actually the idea that certain states don't want to be left in the dust. They don't want to be left behind when their conference counterparts, when their conference rivals are getting kind of similar things. In fact, I remember, and I love this quote, a Republican member of the Mississippi House of Representatives said that he didn't want this legislation. He doesn't want any of this legislation, but he doesn't want to lose a competitive edge in recruiting for Mississippi State and Ole Miss against those who are already in the Southeastern Conference, like Alabama. Alabama has probably one of the most expansive NIL bills out there, even if they haven't passed it yet. So I think that's a big driving force of it as well. So I don't have any inside information into Boise State University's thinking on this or the Idaho legislature's thinking on this. I just don't think it's really been a priority.
All right. So as you look at where this Alston suit's headed with the NCAA and the Supreme Court, and you understand that we're going to have legislation that allows these kids to go out and profit off of their name or their image or their likeness, whether that be through the college football video games, Sam, or like I mentioned, through giving gymnastics lessons or tennis lessons or doing a quarterback camp. It's going to happen, and it's going to be, I guess, handled by either the feds or the states. How does the Alston case and the NIL, if it goes one way or the other, does it have an impact here on how it may sort of filter down?
Oh, it has a monumental impact. It is, I think it's incredibly important for this, even if the Alston case in itself is not directly about NIL legislation. It's about education-based grant and aid compensation. The way it is right now, NIL is going to happen. There's nothing that's going to stop it. You have all these states that have passed this legislation. I think there's a lot of good arguments that the state legislation is unconstitutional, and I think it's incredibly clear that the NCAA is going to challenge it on July 1. They're going to have a lawsuit and a request for injunction in front of a court trying to get that Florida bill overturned. That's going to happen. But the NCAA itself is already making moves on NIL themselves. They've been pushing the federal government to have this, as you said, this preemptive legislation to kind of to really get rid of the state legislation, have one national scheme. But really, at this point, NIL is going to happen. It's not up for debate at this point. And where Alston fits in is that all the discussion about NIL at this point is not about whether it's going to happen, but it's about these so-called guardrails, as the NCAA puts it. The NCAA wants to ensure that there are certain protections against certain types of endorsement deals, certain types of sponsorships that
massage parlors.
That the schools may not necessarily want to happen. The NCAA has come out and said, we're not sure we want college athletes to be partnering with
casinos,
casinos, with gambling companies or alcohol companies or all these different kind of vices. They also don't want college athletes to be partnering with conflicting sponsors.
Exactly.
Where, for example, if Boise State is partner with Ford, they may not want to see their star quarterback go out and shoot a commercial with Chevy,
right?
Because there's going to create confusion there. It's going to dilute their own sponsorship. It's going to be seen as ambush marketing. And where Alston fits in here is because in that scheme, if the NCAA and Boise State prohibit this college athlete from going out and marketing their services with Chevy might actually have an antitrust case there. Because they could they could claim that Boise State and Ford are colluding to shut them out of the market, and that I think would actually be, without knowing any specifics in this hypothetical, it's hard to say whether it actually be a strong antitrust claim, but it would certainly be a valid one, unless, of course, the NCAA has this exemption, has this ability to create NIL legislation on their own without any real impact from outside forces.
All right, Sam, I want to put a bow tie on this, and this is where I'm going to ask you your personal opinion, separate from you being an assistant professor of management at Boise State or a Florida State guy or any other school. This is just you. As you read the situation, and how you would like to see things happen. You wrote this amicus. You have an opinion on how you think the NCAA should handle this Alston case. You probably now also have an opinion on how you think name, image, and likeness should go. So what are those things?
I'm in favor of NIL. I'm in favor of, college athletes being able to make more money off their name, image, and likeness and be able to promote themselves using their name, image, and likeness. I do think that the NCAA should be given some control over that. I do think that there are certain reforms, certain guardrails that they want that are reasonable, that are very fair, to preserve competitive balance to whatever extent it still even exists. But what I want to see is I don't want to see that to happen through a court mandate. I don't want to see the Alston case result in a widespread threshold level statement by the Supreme Court saying that the NCAA for all things related to amateurism is exempt from antitrust law, that amateurism is immediately exempt from antitrust law. Because I want it to happen through Congress. I want it to happen through negotiations with the members of Congress to trade what the NCAA wants in NIL reform, what the NCAA wants for an antitrust exemption, for other reforms to make college sports better for athletes, to give athletes more say, to give athletes more rights, and really just make it more equitable, make it more fair, but between the college athlete who right now is only getting a college scholarship and certain other amenities as well, and the colleges and universities in the NCAA who are making millions and millions and millions of dollars off of that labor.
Okay.
I don't currently see that as an equitable relationship. And I want to see reforms that better balance the scales to that perspective.
Okay, Sam. So now we know what you want to see. As the best guess that you can present, what's going to happen? Is this going to go to the Supreme Court, or the congressmen and senators who are so distracted with COVID and so many other challenges right now, and they always are and they always will be, or at least most often. So what's going to happen? What's more likely to occur here?
Well, we already know it's going to go to the Supreme Court. The Supreme Court has already taken the case. They're hearing oral arguments on this case, in just about a week. I don't know when this is going to pop up, but on Wednesday, March 31st, early in the morning here in Boise, we're going to have oral arguments in the Alston case, and they're going to release their opinion a few months after. As for what's going to happen in that case, it's really hard to tell. This is the type of thing, and antitrust in particular is the type of thing where it doesn't really split on party lines. So trying to analyze this based on, well, there are 6 members of the court currently who are appointed by Republican presidents and 3 members who are appointed by Democratic presidents. That's not really going to work here, especially since a lot of these reforms have been bipartisan, have been both Republicans and Democrats who have proposed these bills. So it's difficult to really give a prediction. I would think that the Supreme Court's going to rule fairly narrowly. I don't think they're going to say that the NCAA is completely off the hook in terms of antitrust immunity. I also don't think they're going to say, well, we're removing everything we've said before about amateurism being this positive thing that you should look at, and the NCAA is now completely vulnerable to antitrust attack. I think they're going to kind of rule somewhere in the middle, where they're going to say amateurism should be given some deference, just not as much as some courts have done in the past.
Should they do that, then NIL and the NCAA, they're going to like that, right? That's going to be in there. If they can still set some rules that do stand, they'll look at that as a win.
I think so, though it really does depend on exactly what they're going to say on there. And I should mention, the after effects of this are already going to be felt. There's already 2 lawsuits in the Northern District of California by college athletes challenging NIL rights, challenging NIL legislation that's been proposed by the NCAA. So this is coming. It's going to come right after the Supreme Court decision, and the Supreme Court decision is really going to impact that legislation, or that litigation. And then as far as Congress goes, like you said, Congress is super distracted right now. They don't have time necessarily to be discussing college sports, but it is the type of thing that has been gaining momentum, especially over the past couple of years, where you have a lot of legislatures that have taken a really keen interest on this. In fact, there's 6 federal bills that have been proposed over the past year or so in very different fashion have proposed to kind of preempt the state legislation, give more federal oversight over this, and give more federal control over this. So I think the NCAA is going to continue to lobby Congress. I think that the advocates for the athletes are going to continue to lobby Congress, and there is going to be a federal law in place fairly soon. I do think it's going to take some time, and we'll have to see what happens in the meantime.
Well, the NCAA wants to make a ruling by this football season. So that tells me
They do.
September 1 of this year, they want something that they are going to say is going to hold water. But we all know that that can change, right? If somebody
For sure.
rules something else, doesn't matter what they think, I guess.
Yeah, and if anything, for the NCAA, we will almost certainly, in fact, I don't see any possibility that we won't have a decision in the Alston case before September 1. So probably closer to mid-June, we'll probably have a decision, though that's, it's very hard to predict with the Supreme Court.
Yeah. Well, we may be coming back to you for that, Sam. Thank you so much for your time.
Hope you do.
Appreciate it and enjoyed it. And thanks for coming aboard.
Absolutely. Thanks so much, Jeff.